Welcome. We're taking a close look today at something really critical, maybe even a bit misleading, in personal finance. It happens right when someone files for bankruptcy and gets to the property section on those forms. Specifically, we're zeroing in on that moment you check the box saying, I surrender this property. Seems simple, right? But most people think that's it. A final goodbye to the house, the car, maybe a timeshare. They think all the responsibility just shifts to the creditor instantly. Our examination today is informed by the legal analysis and, well, the practical findings from Francis Geraci Law. We're pulling out the core knowledge from their work, making sure you really grasp the, frankly, severe difference between ending a debt and actually ending your ownership.
That's absolutely key. Our goal here is to unpack that surprising and sometimes really expensive gap between clearing your personal financial obligation on a loan and clearing the legal title to the property itself. The main message we found, and it's crucial, is this. Bankruptcy clears your debt, but, importantly, not your deed.
And that's the hidden trap, isn't it? You might feel the sense of financial reset after filing, but you could still be on the hook unexpectedly for things like monthly fees, property taxes, maybe even huge liability if someone gets hurt on property you thought you'd already given up. So let's figure out why the bank doesn't just, take the keys right away.
Okay, let's get into this core misunderstanding. When someone ticks that surrender box, what they think they're doing is telling the court, I'm done with this asset, the creditor can have it.
Exactly. That's the common assumption. But according to the legal reality, checking that box, it's really aimed squarely at the debt.
Okay, so it's about the loan itself, not the physical house or car.
Precisely. When you file bankruptcy, you're discharging the promissory note. That's your personal promise to repay the loan. That's specific obligation. It's wiped out. But property ownership, that's governed by the deed, by local real estate law. And the bankruptcy process doesn't just automatically override that.
So the property legally stays yours. Yes, it remains titled in your name. It just sits there, legally yours, until the creditor actually completes a transfer of ownership. And that usually means a foreclosure process, which can take a long time, or until someone else formally buys it.
Right. So the bankruptcy court confirms you don't owe the money anymore, but it's not acting like a real estate agent signing the property over for you.
That's a great way to put it. The bank has a claim against the property because of the unpaid debt. The bankruptcy deals with your personal liability for that debt. But to get the title clear, the bank then has to take separate legal action. It's called an in rem action, meaning against the thing, the property itself, to finalize the foreclosure.
And that distinction is what catches people out and leaves them vulnerable.
It really does.
So this flips the whole thing on its head. If the property's still in my name, even after the debt's gone, what are these ongoing liabilities? I mean, surely the bank takes over cutting the grass and paying taxes once you file surrender.
That's the assumption, and frankly, it's a dangerous one. Because the title hasn't changed, you, the filer, are still legally and financially responsible for a whole list of things. It's surprising.
Like what specifically?
Well, think about the non-mortgage payments tied to ownership. Real estate taxes are a big one. If they keep adding up, the city or county sends the bill to the owner listed on the deed. That's still you.
Okay.
Then there are city ordinance violations, lawn not mowed, exterior needs repair, broken window. The fines come to the owner of record. Again, you.
Wow.
And these aren't trivial amounts. We've seen cases where years of these accumulated fines, or maybe homeowner association dues, condo fees, they can really pile up, sometimes nearing the amount of the original debt they got rid of.
Okay, I get the financial side, the fees and taxes, but what about, safety? If I surrendered a vacant house 2 years ago,
Yeah?
am I still responsible if someone, say, trips on the sidewalk out front?
Yes. In essence, from a legal liability standpoint, you are. You still hold general tort liability for injuries or damage occurring on that property. The classic stark example is exactly that. Someone slips and falls on an icy sidewalk in front of the house you surrendered months or even years ago.
And because my name is still on the deed?
You're likely the primary defendant in that lawsuit. The bankruptcy cleared your mortgage debt, yes, but it didn't remove your basic owner's duty to maintain a reasonably safe property for the public.
So you really can't just lock the door, maybe mail the keys to the lender, and wash your hands of it.
Absolutely not. The lender has to actively legally take the property back. And if they delay, which, let's be honest, they often do if the property isn't valuable to them,
Then all that liability just stays with the person who filed bankruptcy.
it rests squarely with the filer.
Okay, so talking about speeding things up, lots of people try to avoid that long foreclosure wait by offering the lender a deed in lieu of foreclosure, basically saying, here, just take the deed directly. That sounds like the obvious fix.
It sounds ideal, doesn't it? Because it transfers the deed right away, cutting off that liability. But here's the catch. The lender has to agree to accept it. They must consent to take ownership. They're under no obligation to accept a gift-wrapped property, especially if it comes with problems.
They can just say no.
They absolutely can and often do. For instance, the analysis from Francis Geraci Law points out that in states like Illinois, a lender can even accept a deed and then void it later if they discover the property is more trouble than it's worth.
Void it after accepting it. Wow. What kind of trouble makes a bank refuse a property they technically have a claim on? It's not just about low value.
A low value is part of it, sure. But lenders are thinking strategically. The second they take that title, they inherit all the responsibilities. Think about hidden costs. Maybe there's environmental contamination, old oil tank underground, asbestos, mold. That becomes the bank's cleanup problem the moment they own it.
Ah, okay. Things you wouldn't know from the outside.
Exactly. Or maybe there are other liens on the property. An IRS tax lien, a judgment from another creditor you owed money to. If the cost for the bank to clear off those junior liens is more than they think they can sell the property for, they'll likely refuse the deed.
So they'd rather leave you, the original owner who filed bankruptcy, holding the bag.
It sounds harsh, but from their financial perspective, yes. They might prefer you remain the responsible party, dealing with fines or potential lawsuits, while they wait for the market to improve. Or maybe just let the property degrade further if it has no real value to them.
So the pattern is assets with negative equity or high hidden risks. If the bank runs the numbers and sees a loss or a potential liability headache,
They'll often refuse to take title. And this isn't just about houses. It applies to other assets, too, sometimes smaller ones that can be just as problematic, like cars or timeshares.
right, let's talk about those. Cars seem like they'd be simpler.
Generally, yes. Vehicles are personal property, chattel, usually easier to handle. Most times, the lender accepts the surrender in bankruptcy. They arrange to pick up the car, sell it, and the discharge loan is the end of it.
But you mentioned an exception.
There is one, the junk car. If a car is basically worthless, maybe it's wrecked, very old, needs major repairs, the lender might decide the cost of towing, storing, and selling it just isn't worth it.
So they just don't pick it up, leaving it with the filer.
Exactly. And then it just sits there. Maybe it's parked on the street accruing tickets or violating local ordinances. If it's derelict, it can become a real nuisance.
Is there a way out of that?
Yes. The sources we looked at detail a specific legal tool. Francis Geraci Law, for example, can help file a motion with the bankruptcy court to redeem the vehicle for its actual junk value. This could be just a nominal amount, sometimes even $1. If the court approves, the filer pays that tiny amount and in return gets the clear title from the lender.
Ah, so then they can legally scrap it or donate it or whatever, get it properly disposed of.
Precisely. It ensures the junk car doesn't become this zombie asset, causing problems years later.
Okay, that makes sense for cars. Then, timeshares. You mentioned they're a frequent issue, and I can already see why. Low value, high fees.
Oh, they are the absolute poster child for this whole debt not deed trap. Timeshares often have literally zero resale market value, sometimes less than zero, because they come with mandatory ongoing maintenance fees and special assessments.
And those fees don't just disappear with the loan discharge.
Not necessarily the ongoing ones. The original purchase loan, yes, that debt can be discharged in bankruptcy. But those maintenance fees, they're often tied to the ownership interest through covenants that run with the land, legally speaking. And the timeshare companies, they almost never want the unit back. They make money from the fees, not the underlying real estate. So they're very resistant to taking title.
Leaving the owner stuck with fees for something they don't want and can't sell.
Exactly. And this leads us to a really crucial point about strategy, how the type of bankruptcy you file interacts with surrendering property like this. Chapter 7 versus Chapter 13 makes a huge difference here.
Okay, how so?
Let's use an example from the materials, the Harris family.
All right, tell us about the Harrises.
So the Harrises had this timeshare they couldn't afford anymore. It was costing them, say, $120 a month just in fees. Plus, they had some credit card debt they were struggling with. But importantly, they were current on their house payment and their car loan. They absolutely wanted to keep their home and their car.
Okay, so the goal was ditch the timeshare debt and the credit cards, but protect the house and car. A common scenario.
Very common. Their successful strategy was filing Chapter 7 bankruptcy. Chapter 7 is often called liquidation, but it's really about a clean discharge of unsecured debts. They listed the timeshare to be surrendered, Discharging that obligation, they discharge the credit card debt, and crucially, to keep the house and car.
They did something specific for those loans.
Yes, they entered into reaffirmation agreements for the home and auto loans.
Can you quickly explain reaffirmation?
Sure, a reaffirmation is basically a new promise made during the bankruptcy to keep paying a specific secured debt. The debtor voluntarily agrees, and the court usually approves it, making them personally liable for that loan again, even after the bankruptcy discharge. It's the standard way to keep secured assets like a house or car when you file Chapter 7.
Got it. So Chapter 7 worked for the heiresses. How would Chapter 13 have been different?
Well, Chapter 13 is a repayment plan, typically over 3 to 5 years. You propose a plan to pay back some or all of your debts using your disposable income. Now, if the Harrises had filed Chapter 13, it gets complicated. That timeshare company, even though the underlying loan might be discharged, could potentially file a claim in the Chapter 13 plan for the ongoing fees or the total contract balance.
Wait, even though they surrendered it?
Potentially, yes. The argument could be, look, the debtors are keeping their house and car through this plan. They clearly have some disposable income, according to the bankruptcy means test, so they should pay something towards this timeshare obligation as part of their repayment plan.
That's wild. So in Chapter 13, they might have been forced to keep paying for that timeshare they hated just because they had income going into the plan for other things?
It's a definite risk. The creditor has more leverage in Chapter 13 to argue for payment on unsecured or potentially secured claims like ongoing fees. Chapter 7 allowed the Harrises a clean break from the timeshare entirely.
Okay, that really highlights how the choice of chapter is critical when you're surrendering property, especially problematic property like a timeshare.
Absolutely crucial. It dictates whether that lingering debt truly gets eliminated or if a creditor can find a way to keep you on the hook through the repayment structure.
This all circles back to that core finding from the Peter Francis Geraci Law materials. Bankruptcy is this incredibly powerful tool for resetting debt, but it's not some kind of, I don't know, magic wand for property ownership. Managing the property transfer, getting it out of your name, that's a whole separate task that needs careful handling.
It absolutely must be handled deliberately. The firm's approach really boils down to managing that post-filing risk proactively. Step 1 is meticulous identification. You need to list everybody with an interest in that property. Mortgage holders, sure, but also any second mortgages, HELOCs, judgment lien holders, the condo or homeowners association, and even the utility companies.
Get everyone on notice.
Exactly. Step 2 is formally notifying them by listing them correctly in the bankruptcy petition schedules. This gives them legal notice of the filing and your intent to surrender. Step 3, and this is ideal if possible, try to negotiate that deed in lieu or maybe even a short sale before you file bankruptcy. If you can get the title transferred cleanly beforehand, you avoid all this post-file in limbo.
That makes sense. Handle it up front if you can. But what if the property isn't underwater? What if there's actually equity in it?
Good question. If there's significant equity more than your allowed exemptions, the safest path is often to let the bankruptcy trustee handle the sale.
Why the trustee?
Because the trustee has a legal duty to sell assets of the estate for the benefit of creditors. They will manage the sale process, pay off the liens, pay the creditors according to priority, and if there's money left over after exemptions, it comes back to you. Most importantly, when the trustee sells the property, the title transfers clearly through the bankruptcy court's authority. That gives you the cleanest possible separation from any future liability associated with that property.
Okay, so the big picture here for anyone filing. Understand that getting rid of the debt payment is step 1. Getting the property legally out of your name is step 2, and it doesn't happen automatically.
That's the crux of it. Working with professionals who really understand both bankruptcy law and real estate law, that intersection is key to making sure that eliminating your debt doesn't accidentally leave you exposed to years of ownership headaches.
Makes perfect sense.
So just to hammer it home, bankruptcy helps you eliminate the debt, the personal obligation to pay. It does not automatically eliminate legal ownership. You can walk away from the payments, but you have to ensure actively that your name comes off that deed to truly cut off liability for taxes, for fees, and especially for injury claims.
A really critical and potentially very costly distinction. Thank you for walking us through the source material on this. It's definitely more complex than just checking a box.
It certainly is.
All right, before we wrap up, here's something to think about. A final thought based on what we've discussed. Imagine you surrendered a rental property in bankruptcy. It's low value, maybe even rundown, and you suspect the bank won't bother foreclosing for years. Knowing you're still technically liable, what practical steps would you take immediately, things related to the physical property or maybe administrative steps to minimize your risk of being sued if someone gets hurt there before the title eventually transfers? Something to mull over. We'll see you next time.